Welcome back to the Boardroom Conversations podcast with Collier Bristow. I'm Helen. I'm an associate in the corporate team and joined again by Ragavan.
Hi, Helen. Thank you for having me back. Hopefully this means that last time you thought my content was okay. I'm a partner in the corporate department and also chair the private equity audience group. So I think today's topic of conversation is quite close to my heart, as it's really important when you're doing private equity deals.
Brilliant, which tees me up nicely to let people know that today we're talking about articles of association and shareholders agreements, which on first hearing the topic, you might think this doesn't necessarily strike a chord, but actually, as you just alluded to, it's incredibly important. Perhaps to kick off, we should just cover off what actually are the articles of association for a company and also a shareholders agreement.
Right. So the way I'd conceptualize the articles of association of a company they're the actual constitution of the company. They're a publicly available document which sets out clearly the rights between the shareholders and indeed the company. It forms a contract between the shareholders and the company. And the purpose of making them public is that so whenever any individual interacts with the company, either on a corporate level, individual level, or as a shareholder, the rights of the shareholders are kind of clearly set out. And because it's a publicly available document, because sometimes companies don't have bespoke articles, they have model articles, which are kind of a basic set of rules of governance for the company, they're often supplemented by a shareholders agreement. And that's a document which is traditionally not publicly available. It's a private contract between the individuals. But as I say, it can supplement the relationship between the shareholders and the company. And I think the utility of that is that sometimes, as you say, you can keep some items private.
Absolutely. And I think just thinking back to it, you mentioned the model articles a moment ago, which are the sort of the default articles that might apply if you weren't drafting your own bespoke articles. Although I suppose it's worth mentioning actually that you could simply amend the model articles so you have certain bespoke provisions, or you can have an entirely bespoke set of articles, can't you? But why is it important to think at the time of adopting your articles what the appropriate road to go down is for that?
It's important because the articles will be the driving force between how decisions are made, but it'll also be the driving force about how the economic rights of the shareholders are divided up. So if you want to ensure that you can have different dividends declared on different classes of shares, for example, if you have anything other than a vanilla shareholder base and you want to do something that's a bit more bespoke in terms of having a waterfall of economic rights, it's really important that you look at your articles and see whether they fit the purpose. Because model articles only legislate for one class of share capital with equivalent rights between all the shareholders. That may not be fit for your project. If you're setting up a company, and this is why I mentioned private equity at the outset, where there's a distinction between the investors and the management team, for example, you may want to create more than one class of share capital. Some classes, one class to give to investor, which kind of protects their rights as an investor, and one class to give to the management team, which kind of incentivizes and aligns their economic return with the performance of the company. And that's kind of a traditional model, but you can't do that with just model articles. You need to invest time in both structuring the articles and producing a bespoke set.
That makes sense. Yeah. And so then the shareholders agreement obviously has to interact with that. How does that typically, in your experience, how do you find that works?
Well, I think the main advantage of having a shareholders agreement is that it's very supplementary to the articles, but it's also a private document. So I think it's important that some things that you wouldn't ordinarily want to put in the articles, for example, you may want to not make transparent to the world that certain parties have veto rights or consent rights. But the investor, it may be important that an investor, for example, has consent rights so that they can veto substantive decisions being made. And ordinarily that's not the kind of thing you want made public, but you can put that in a shareholders agreement and therefore enforce it separately as a contract between the parties. So that's often one which we kind of see not in the articles, particularly as it doesn't impact the share rights directly. It's more kind of a super veto right for a certain party.
That makes a lot of sense. And I actually think that's a really good example of a circumstance where actually that's not necessarily something that you want to be out in the public domain. So following on from that, who might be listening to this, what would you say are the key considerations to bear in mind when preparing articles or a shareholders agreement? If someone's thinking, actually, I might need to do that, what, if they were to come to us and ask for some advice, what would you be saying as a starting point?
I think is not presupposing anything when a client comes to you. You need to kind of listen intently and particularly about what they want to achieve, and then work back from that outcome. So I think that's always the key thing to try and dial into. You need to understand what your client wants to achieve, and different clients will want to achieve different things. So, for example, an investor is going to be ultimately focused on an exit. And it's really important that management and the investor are aligned on those. And that's when projects and private equity investments work best, is when management and the investor are aligned. But because of that focus on exit, then potentially the ability to drag along other shareholders when a suitable exit comes along is going to be important. And apologies, when I said I'm talking to you, Helen, I know you know all about drag along, but just in case anyone's listening and doesn't know about drag along. Drag along is essentially an ability for a majority of the shareholders, which may be just one shareholder, but you set a threshold, say, 50% or 75%, depending on who are the parties involved. And once that threshold is surpassed and 75 or 50% of the shareholders want to sell, they can compel the remaining minority to come along with them and sell their shares as well. And I think the utility of that is that everyone is treated equally. So the minority are not prejudiced. However, the minority can't stymie an exit or ransom their shares and therefore prevent an exit happening. So it's kind of a traditional way to ensure that an exit can be achieved. And there's obviously something that if you're an investor, you'd probably be looking for. The corollary of that, because although I do a lot of private equity work, acting for investors, also act for management teams, is ensuring that you have a tag along right as well. So that as a minority, if the majority shareholders wish to sell, you can tag along with that sale and therefore aren't left high and dry with a new majority shareholder who you may not have a previous relationship with or the same kind of relationship you had with your previous majority shareholder. So I think it's important when you're drafting shareholders agreements, when you're drafting articles, to shape back from the final outcome you want to achieve. And then pretty much the rights and the obligations in both documents take care of themselves. And, you can make them as simple as complex or as complex as you want.
That makes a lot of sense. I suppose it's really going to depend, as you sort of mentioned, on what your focus is, whether you're the shareholder who's planning for an exit, in which case I suppose something like the extent of any restrictive covenants that might apply to you will be of significant importance, I would imagine, or whatever your focus is. And actually, even if we take it down a step or two, just even things like hitting the right number for setting quorum can be incredibly important, because you don't want to be stymieing yourself out of the gate by making it incredibly difficult to make decisions, because you potentially have to get all 5 directors participating in every single decision. There can be a lot of different aspects to be considering depending on what stage you're at, I suppose.
Yeah, and that's exactly right. I think once you've understood at a kind of macro level what your clients are trying to achieve, then you can fill in the kind of contractual protections they need. But it's exactly as you say, at a high level, you're looking at control of the company and then the economic outcomes related to the share capital. We're talking about companies limited by shares. So those are the two biggies. I mean, decision-making, control at a board level, and also shareholder level, and also whether we're talking about investor consents from a majority or even a minority on the control side, and also making sure there's representation in the board level, so that you, as you alluded to before. But then once you've dealt with those kind of control mechanics, it's more kind of, well, then how are we dealing with this, the share capital? Do we have preemption rights on transfer of share capital so that other third parties who we don't have a previous relationship cannot obtain shares in this private company? I should have said that on both on this and on the previous podcast, we've been talking about private limited companies, because there's a slightly different regime when you're talking about public limited companies, obviously, and you don't have obviously shareholders agreement when you have a public company. So this is very much something of real utility when you're shaping a good outcome for a private limited company. A lot of people don't want to spend money on bespoke articles and shareholders agreement, but a lot of heartache can be saved if you get some decent articles and a shareholders agreement in place, because it really sets the tenure for any negotiations going forward. And while everything's fine, it's great. But then if you're in a sticky situation, it often helps to have strong rights which work in your favor. And, I can tell you of a number of clients who've had a good result because the documentation has been in their favor and we've thought about what they want to achieve, several years before it's come to pass, and we've legislated accordingly in the documentation.
No, absolutely. A little bit of time and money cost up front can save you a lot of heartache and a lot more money in the long run, which is in my book a pretty good deal. But I think that's probably a good point at which to leave it here for today. And obviously, if you do have any questions, then feel free to contact us. Our details are on the corporate page for Collier Bristows' website. Thanks very much for joining us, and thanks to everyone who's been listening. And hope you'll join us again next time.
Great. Thanks for having me on.